So today, truth about probate tax issues for homeowners. And I want to start with our panelists, and if you guys could introduce yourselves. Linda?
Thank you, Paul. My name is Linda Solesh Reed, and I am a board-certified specialist attorney. My specialty is elder law, and I have a practice in Baldwin Park.
Pam?
I am Pamela Henley. I am a co-founder of All Florida Tax and Financial Solutions. I am a past three-term council member for the city of Edgewood. During the time, I was in charge of budget and finance. I am a past member for finances for the Orlando Ballet. And I enjoy assisting small businesses and individuals with their taxes.
So, Linda, what's the difference between a general practice attorney and a person who serves seniors, a board-certified elder law?
That is a good question. There are very few general practice attorneys, at least in metro areas. Law is become highly specialized, just like you wouldn't want your general practitioner to operate on a brain tumor. When you look for a lawyer, you need to look for specialization. So how I got to be a board-certified specialist is it was passing another test that was right up there in difficulty to the two bar exams that I took. The process involves getting a lot of continuing education in the topics covered, getting peer reviews, and this also requires redoing the process of peer reviews and education every 5 years. So I am now in my third 5-year segment. So I've had a lot of experience, and even though I am board certified in elder law, I am even further specialized. I will only practice in areas where I really know what I'm doing, and that's what I suggest you do if you're looking for an attorney. Not only do they have the license, but how many probate cases have they done? Ask questions like that.
So Pam, on your side, how does an enrolled tax agent differ from a CPA?
Thank you. I specialize in tax. It's very simple. My focus is on the tax laws, and I too had to take and pass a certified test in order to obtain my license. Again, I was going to use the same analogy. It's like when you go to a doctor or a specialist, you go to a podiatrist or orthopedic. Well, I'm a tax specialist. And across the board though, when it comes time, or if you ever had to go to court, we're all equal. Tax attorneys, CPAs, and enrolled agents are the only ones in tax court that can represent you.
Okay, so we got that out of the way. I think that the thing is that our world has become so specialized. As Linda said, you wouldn't go to your general practitioner for brain surgery. And we happen to have a son who's a pediatrician, and it's very interesting because he legally cannot practice outside of the area of pediatrics. So, moving on, we get this question all the time, and people say this, oh, I won't go through probate. I don't have to do probate, or I figured out a way not to do probate. So, what is probate, and does every state go through some form of it?
Okay, that is a great question because I hear that a lot too. Okay, so just in general, you can have a will or a revocable living trust as your main estate planning tool. If you choose a will, the way a will is put into effect is through the probate process. Probate is based on the word to prove. You prove to the court that this document is the original document, and then the court oversees the carrying out of your wishes. And this is very procedure-based. The statutes say first you do this, 60 days later you do that. So I think we'll talk later about whether this is good, bad, but my opinion is it is neutral. It is a process. It's neither good nor bad.
So as we go through this, if you have questions, feel free to ask. I'll repeat the question. We have mic runners. Wait till they get there because we've got to get your question on the microphone or on the tape, and then I'll repeat it. So Linda, I know there's numbers of documents that fall into the process of legality relative to someone's home, and then also the process of final documents. And why don't we go through and kind of do the Cliff's Notes definition of these? The deed on the property?
Okay, well, a deed is the way you transfer real estate. There are different types of deeds, but all deeds transfer real estate.
Okay, and those are, Joanne, wait just a second. Should be on.
I've been wanting to ask this question about ladybird deeds. I was all ready to pull the trigger on that as part of my estate planning. But then I heard somewhere, and I can't remember quite where, that it would affect the, I guess your taxation, your real estate taxes, like you started a base then. Is that any truth to that?
So the question is about ladybird deeds. They're called a couple of different types, a life estate, a ladybird, and how that might affect taxes. That can be a long answer, but we're going to let Linda.
Okay, that's my clue that he wants a short answer at this time. There are a lot of pluses and minuses to ladybird deeds. It should not affect the taxation. If you have your homestead and you get the property tax benefit of having a homestead and you do a ladybird deed, it doesn't affect that, nor does it affect the ultimate step up in basis should you die and pass it on to your relatives.
But while you're living, would it affect the valuation of the property?
So-
Does that deed trigger a valuation?
So to repeat, that does putting a ladybird life estate deed in place trigger anything relative to taxes, Pam?
No.
And if you want more on that, I mean, everybody's staying afterwards, and so they can go into a lot more detail. We actually covered that quite a bit in the spring in a session we did. Power of attorney, Linda. Why a power of attorney and who should have one? I have to always throw the who should have one in.
Okay. Every legal adult, which means all of us in this room who are 18 and over, nope, don't see anybody under 18. In most circumstances, it is the single most important document. It says if you are temporarily or permanently incapacitated, who will be able to carry on the business side of your life, who will be able to pay your bills, transfer funds from one account to the other, sign deeds should you need to sell or buy real estate.
Next, guardianship, declaration of guardianship.
Okay, well, by planning, one of the purposes of doing advanced planning is so that your family will never have to go to court to get the authority to help you if you lose the capacity to help yourself. But lawyers are belt and suspenders type of people, which means that we also have you sign a document that says, on the remote chance that somebody goes to court and files to have a guardian appointed, while I have full capacity, or in my case, reasonably full capacity, I'm going to designate who I want to serve in those roles.
These become, we ask about this when we have consultations with people, if they're transitioning to, say, a community or they're downsizing to another property, because we never, first of all, they're very important documents. Secondly, when we're working with folks, we never know what could happen between now and then, whenever then is. We were with a couple, they're older, the gentleman's had a stroke, she's having some other pretty severe health issues, and they're not going to transition to the community. Their apartment won't be ready till next year. Well, who knows what's going to happen between now and then? And so talking about these documents becomes important, and that's why we bring it up. The will, Linda.
Okay, the will is what most of us think of as estate planning documents. It says who gets what upon our death and who administers the process. It is only effective, it only has any actions when you are dead, and you can change it up until the time of your death or until you lose capacity.
And then trust.
Okay, in this case, we're referring to a revocable living trust, which does all those things a will does, but is active when it's signed and can have some other benefits. So in some cases, it's a good alternative to a will.
So what's the difference between a will and a trust?
In most cases, if you have a trust and it's properly funded, your family will not have to go to court through the probate process. The properly funded is the catch, because a will, you come to my office, you execute it, it's done. A trust, you come to my office, you execute it, and there's a bit of homework that needs to be done, some by you, some by my office, in order to make it effective.
For example, do they have to have a bank account for the trust?
Well, what happens is you would go to your bank where you have your savings and checking accounts, your investment accounts, and you would transfer those accounts into the name of the trust. You still own it if you have a spouse or partner. Both of you still own it. There's no real practical difference in ownership except the way it's treated at your death when it's time to pass it to your relatives.
So Pam, let's talk about tax ramifications. So obviously at some point, we're all gonna sell a home. And when someone sells a home and they're still living, are there any tax ramifications?
If you've been in your home and lived in it for a long period of time, typically what occurs, if you're married filing joint, you can get what's called the primary home exclusion. This exclusion, how it works is that you have a $500,000 married filing joint exclusion, $250,000 if you're single. And it is added to the cost basis of your home. So if you purchased a home for $100,000, let's say you purchased a home for $500,000, you did improvements of, let's say, $25,000 over the period of time that you lived in the home, and then you sold it for, let's say, $700,000. Long story short, there would be zero capital gains on the home, because between the basis that you have in the home of the purchase price and the improvements, plus your primary exclusion that you're going to get of $500,000 married filing joint, wipes out any and all gains on the home.
Okay, so, hold on, Joanne, let me bring the mic.
As far as record keeping for the exclusions, you own a home for many, many years, sometimes people, and myself, aren't so great at keeping the receipts, et cetera. How diligent do you have to be? How closely do they look at that?
And that's a really good question, because many of us bought homes 25, 30 years ago when the average price in Orlando was probably $100,000. The average price in Orlando today, or the median price, is $450,000. So we're seeing huge escalation and a huge amount of equity. So Pam?
It does come in play. We do see, a fair amount of older people that come to us and they don't have their initial selling documents. There are ways you can go through property tax appraiser. They will have a record of what the home was sold for. So we can use that as the cost basis. The property, the things that you probably should try to keep intact and in some sort of folder. In my house, we call it the hurricane folder. So if a hurricane comes, we grab this box. It has all of our important documents. And in my documents, I have what I purchased my house for. I have the major improvements that the receipts are in there as well. It's also a great idea because I like redundance. I have a share file. I have my documents scanned and they're up in the cloud as well. So if something were to occur, I have those documents. And you would, only time that you truly would need those documents is when you sell the home and you would want to have, as your accountant, some degree of certainty of what we're putting in as your cost basis. So, I have a case right now that we're trying to work through where it's an elderly lady, she's selling her home in New York, and throughout the years, it's a farm and houses and assets have been added to it and the documentation's not there. So what we are doing is actually taking photographs of what the house looks like now, what the property looks like now, and getting appraisals done of it so that we know if there's ever an audit, here's our documentation.
So what about after death? Are the tax ramifications? Well, first I want to ask you, that 500,000, 250, 500, is that to Florida, specific to Florida?
No, it's across the country.
So that's a federal?
It's a federal law.
Okay.
I have a question. My home, I was married when I built it, divorced shortly after, remarried 8 years ago. Now, that 500,000, if one of us should pass away before the house is sold, does that extra 250 get dropped off of there? Or because it's been, and it's in both names now, would it still get the $500,000 exemption?
So we get that question all the time, and that's a very good one. The question is, if a couple, and both names are on the deed of the property, and one of them dies, does the $500,000 stay in place, or do they lose part of it?
You have, if you've been in the home 2 out of the past 5 years, and you can claim it. Okay?
Even after one is deceased?
If one is deceased after, you get a 2-year period, and then if you go to, once your status on your tax return hits single. So it really is gonna depend when the spouse passes, what tax year you're on, because sometimes you can actually straddle a year. And then, as soon as your tax return says that you're single, at that period of time is when you're going to drop down to the 250.
Florida law and the way they handle homestead and other things on the properties is what's ever in place on January 1st lasts through December 31st. So it hangs until the following year. So tax ramifications after death.
I have a question, and that was there a step-up in basis that would apply?
Okay, so a step-up basis. You want to talk about what that is first?
Right, so step-up basis usually occurs when let's say I'll take myself as an example. If I were to pass away, and then my children would come next in line to receive my assets. So at that point, when my children step in, my home value, what I purchased, and use easy numbers, I purchased the house for $100,000, but it's valued at $400,000. So at that period of time, when I pass, the value of the home passes to my children at $400,000. That's called a step-up valuation as current laws. Now Congress is talking about taking that away. So,
Yeah.
yes. So that can
So
change.
with that, with the step-up basis, using your example, there would be no tax ramification to the heir who inherited that property.
Correct, from if they sold it directly after they received it. And let's say they held it for 6 months and the value of the home rose in 6 months, because we all know our market is just crazy with house prices. So if it rises in the 6 months, then yes, they could incur a gain on it, because they would incur the gain from the time that they receive to the period of time that they sell.
Now, that may bring up a question in your head about, well, do we sell the home in the estate, or do we pass the home to a child or an heir and let them handle the sale? And that's a great question when you're sitting in front of Pam and Linda in their office, because that is a very specific to the individual circumstance. I know that because I asked that question. What types of records? Well, we've already done that for the documentation for the capital gains on the property. So Linda, from a legal standpoint, the Florida homestead law, how does that affect the sale of a property in general and also at death?
Okay, first of all, let me say that Florida homestead law is a legal nightmare.
You want to tell them what homestead law is?
Okay, well, there are three uses of the word homestead. One is constitutional, that says that our homes, our primary residences, are protected from creditors. That's great. The statutory version of homestead says, and this is where we might get into issues, is that if you are married or you have minor children, you cannot give your homestead to anybody else. You cannot leave it in your will to somebody other than your wife or your minor children. And then there is the ad valorem property tax, meaning of homestead. That's the one we're all most familiar with, where you get a tax break on your property taxes, and it doesn't, there's a cap on the increase every year. So how does this affect the sale? If you are in a second marriage, if you have a blended family, if you have a homestead, see your attorney about what to do, because if the most common problematic scenario I see is that a couple gets married, it's their second marriage, they agree that the wife, Jane, owns the homestead, they'll live in it together, but she'll be able to pass it to her children. When Jane passes away, surprise, her husband gets to pick either a 50% interest in the house or a life estate in the house. So, or he gets it and he just gets a choice of how to take it. That is an unintended consequence, but that is what the statute says. So homestead, the takeaway is, if you and your spouse did not buy it together many years ago, it's worth speaking to an attorney to see exactly what happens and to make sure that it goes where you want it to go at the time. Did I address the question, Paul?
Yes, but
Okay.
there's another piece of that. You said when you create a blended family.
Yes.
What about when you uncreate a family, a divorce?
A divorce.
Does it matter that the spouse who didn't stay in the house, his name stays on the deed? We see it all the time.
Yes, again, that is not a matter created by law, but yes, that is problematic, to say the least. Oftentimes, what happens is there is a marital settlement agreement or an order by a judge that says, you, Joe, you have 30 days to sign your title over to your ex-spouse. Well, Joe and Jane weren't getting along because they got divorced, so Joe delays, and then Joe dies. And then Jane is really in a bit of a mess to get Joe's estate to effectuate the transfer back to her, and it does create problems if there's a mortgage on it. It's very complex, and unfortunately I don't have good answers for this because it is very situational how you solve it. But it's an area, just if this crops up in your life, I'm sorry first of all, but then it would be worth your time to deal with it as soon as you become aware of it, rather than wait until a death or something else forces you to deal with it.
We've run into this more times than we'd like to count, and the internet is a wonderful thing, but legal documents on the internet are not a wonderful thing. And we actually had one, and they said, well, we just pulled some documents off the internet, we filed them, went down to the courthouse, and we're divorced. But your ex-husband's name's still on the deed, and he doesn't like you. So it created a real problem. Or the ex-spouse is deceased. We've seen some crazy stuff there. How does Florida homestead law impact property taxes? Linda touched it, but didn't really go into numbers.
She did. You can get an exemption with homestead, and I'm sure many of you are aware. You do have to apply for it when you purchase your home. But the exemption can be up to $50,000. And the way it works is they take the first $25,000 assessed value and they reduce it to that amount. The next $25,000 is not subject to an exemption. And then if the value of your home exceeds that amount, then they apply either the balance or the next $25,000 of the exemption to the assessed value. But what they do apply it to, and they take away on the second portion of the 25, it's not applied to your fire and the county, your libraries and things like that. So it's just on the portion of the home itself, but it doesn't affect the other taxes. Sure. So I gave an example. Here's an easy one, and this is really nice. They had a home that was for $90,000. Okay. The first $25,000 is fully exempt with taxes. The next $25,000 is not fully exempt. Okay. So you have a fully exempt portion. If you go over the 90, and you have what's left, then that next 25,000 is not subject to the exemption. And then the third lot is subject to the exemption, and it does not include the school districts in their taxes on the second. Correct.
How do you get that? What's that criteria?
It's automatically applied to you by the county that you live in. Yeah. Mm-hmm. They're aware, they know.
So with property pricing the way it is today, from a practical standpoint, people are getting the full 50,000.
They are getting the call.
Well, there's a way to look for it, and if you give us a call, we can show you how to do that, because it's in the public records. We're in them every day, so we're very familiar with it. So, other than the 50,000, I do want to talk about something while you're there. What about assessed value, what we call taxable value? How does that handle? It's not technically homestead, but what's that in Florida?
So,
Price increases, the ability to raise taxes.
right, so they have a cap on it, and the cap is 3%. It's all that they can raise it when they do it.
It's a lesser of consumer price of
Right.
3%, but
Correct.
practically speaking, it can never be more than 3%.
That's the cap.
And that's what we call the tax assessed value, or a tax appraised value in your home. And if you look at it, if you've been in your home for any period of time, it's substantially less than what would be the sale price of the home. We sold a home a few years ago, and I think our tax assessed value was 30% of the true value of the house. It's a wonderful thing in Florida. A lot of states don't have it. People were becoming tax poor in their homes as the prices escalated. And I think it was 1992 when that went into effect. So other than the 50,000 deduction, what other things might be applicable for somebody? I threw this out to both you guys. The one I'm thinking of,
Affordability.
well, we're going to come back to portability.
Okay.
But relative to the bottom line, each year, the one I'm thinking of is disabled veteran.
Veterans,
Yes.
that
Yes,
No.
that disabled veterans, spouses, surviving spouses of, veterans as well. There's another one that, if you add on to the house, it's a construction. If you bring in your elder parent into your home, and it's called let me find it here. There's a form too, because I knew somebody would want it. It's the DR 501 PGP, and we should put that in the link. and it's called the Constructions of Mother-in-Law Suite. So if you build a mother-in-law suite onto your property, you are eligible for an exemption or a reduction in your property tax.
And that's certain, that's,
It is for an elderly, if you have to have, for an elderly, you know, you're bringing in somebody elderly that you're gonna take care of, is the purpose of it. And you do have to apply for this yearly. So that's the downside on it.
it doesn't apply to that boomerang child that came back.
I was thinking the Airbnb and the.
And we don't
Yeah,
want,
no.
and we don't want it to. So there's numbers of others, 100% disabled veteran, over 65
Right.
has another one.
Right.
We just learned about that recently, we're dealing with a 100% disabled veteran. So make sure you ask when you're talking to your accountant and your attorney. So after death, what is the time frame to settle an estate?
I can tell you the statute and then stories from real life. For probate, the statutes are set up that it's completed 1 year from the start. In real life, if the stars align, if the judge isn't backed up, if all family members are cooperative and computer savvy, you might get it done in 6 months. Doesn't happen. A year is really quite reasonable. That doesn't mean that it takes a year before you can distribute some benefits to the beneficiaries, but a year is a good estimate. Can take shorter, and there's certain types of probate that are much shorter. If you don't have if you don't have assets that are above 75,000, there's it's called a summary probate administration. It's an informal administration, and those do tend to go much quicker. The things that delay any probate administration are uncooperative or missing beneficiaries, because you need to know where your beneficiaries are and they need to consent to getting money, and you would think that would be an easy consent to get, but it's often not. And the other thing is the type of assets. If you own a home and you have an investment account, simple. If you, I'm forgetting the acronym, but the electronic artwork, if you own that, if you own crypto, the very fact of the assets being difficult might delay the process.
For example, there might be someone out there who is on government supplement because of their disability or their capacity, and they may be disqualified because part of that's financial. So there's some real complexities that can happen. Did I say that right?
Oh, right, just to be clear, that is on the beneficiary end. As we look at estates to deal with probate, or we hope we get this when somebody's creating their will or trust, but if you have a beneficiary who is getting government benefits that are based on financial need, you want to plan in advance so that their inheritance benefits them but doesn't kick them off of their benefits. You can, in some cases, fix it if somebody who is on benefits inherits something outright, but as always, it's easier to do it if you plan in advance rather than you try and fix something.
So question, you said statute is 1 year from start. Define start.
Okay. The process is the personal representative, which is executor in some states, personal representative here. They typically would retain me. We have to we have to draft some pleadings. We have to get them to sign it. We have to get other beneficiaries to agree with them being personal representative and administering the estate. That could be the first potential. Again, against your own self-interest, if you're due to inherit, I would want to say, yes, do it, but not everybody does. The court gets all the necessary paperwork, and the court signs orders that give the personal representative the authority to do whatever they need to do to administer the estate. That's day one.
So, when there's a death in the family, obviously it's traumatic, a lot of emotion, a lot of things are going on, planning a funeral, trying to get family in and out of town, deal with things. So from a pragmatic standpoint, how soon should somebody, after the death, the person who's gonna be responsible, the executor, the personal representative, when do they need to be seeing somebody to get that started? Whenever they get around to it?
Well, in an offhanded way, yes, because when you are dealing with the death of somebody, some people deal with death and mourning by keeping busy. And if the personal representative of one of those type of people, I say, I will get you in this week, because clearly they need to do something, they need to take action. If not, if they need time to plan a memorial service and deal with the family and things like that, I'd say, probably within a month would be good. I mean, there's really no outer time limit. It's just you do, because you really are looking at least a year. You want to not delay too long. So as soon as you're emotionally ready. I mean, again, lawyers, besides being lawyers, we have feelings, we're people, and when you're dealing with probate or trust administration, I see a skeptic there, but we have to realize that not only are we dealing with a statute and probate, is that you're dealing with people who are dealing with trauma, basically.
So got a question from Joanne, and then Marilyn? Well, Marilyn got Mike first. No, go ahead.
Oh, because it's here. You have one adult son, very adult son. The best way to deal with bank accounts for somebody who's gonna have to come in perhaps and need access to that, and say if we both the one to the train at the same time, or the last one to go or something, is it payable on death, or how do you do that so that he can come in and automatically have access to whatever accounts he may need to?
Is that you, Pam, or is that Linda?
That's Linda. Payable on death is automatic only in the legal sense, because my own experience when my mother passed was payable on death stretched past 2 months. And I know how to fill out paperwork. We may have a conversation after, but the short answer is what I would suggest: on one account and one account only, where you don't accrue a large balance, make your son the responsible party, co-owner, but only one account. Yeah, we can talk later.
So, Joanne?
And that was part of my question as well, so thank you, Marilyn. But more specifically, if I have payable on death on all my brokerage accounts, bank accounts, and in my will, though, I want to leave specific amounts to certain people that are in those accounts, would probate honor those?
No.
So the question is, she wants to, specific amounts to whomever, how does that get handled?
Okay. When you have a payable on death account in a bank or an investment, that is a contract. And when you die and when proof of your death is presented, the banks will honor the contract and pay the money out. Your will does not come into play at all. So again, that is a more complex type of.
Would having a separate account set aside for those people, the will would then.
Yes, that is one
So
way.
there's ways to handle it, but I think that gets into a lot of
Yeah,
complexities,
that's-
depending on what you're trying to get
Yeah.
to. I want to back up just a second. We were talking about practical, somebody getting the probate process started, the after-death process started. And if there's a property involved, a physical residential property or a real estate property, don't drag that out, particularly if it's empty. The first thing that will happen is the insurance company will drop you as soon as they find that's an empty property. That's the reality of Florida. We're gonna go over that in Downsizers Club, by the way. The second thing is, you have a depreciating asset the day that becomes vacant, because anything and everything can and will go wrong with it. somebody will break in. We actually had a home that we were dealing with, and we were working with the person who was managing things, as the personal representative. We tried to get them to hire us, and they chose not to, that's their thing. But it was a $450,000 house at the time, this was many years ago. And there developed a leak. And by the time they called us and said, look, we need to get you guys involved, there's black mold growing across the ceiling. And that $450,000 house became a $75,000 piece of dirt, because the house was completely destroyed. And so, as I said, anything and everything can go wrong, and it just needs to happen. Our old neighborhood, which is not terribly far from here, it's in the city of Orlando, there are 2 homes in there that the people, and we happen to know who lived there, who died years ago, and those homes are still sitting vacant. And it's crazy. So, next, we're gonna move on to cost and deductions, ability to deduct things for ourselves as we get older and we have health issues and we need help in our home. So when we start bringing in caregivers, we were with a couple and they had a caregiver 4 hours a day for the one who had a stroke. Is any of that tax deductible?
It is, absolutely.
Does it have to be a specific kind of caregiver? Can it be a companion care? Do they have to be medical?
Typically, my understanding is that it needs to be that's what it is. I have seen them where they're personally set up with an attorney where the caregiver is the individual and we have written off the medical side of what the individual performed for that person. And it becomes, because it was drafted through an attorney, it became a document that we could use as a tax deduction. Now, if it's through a medical facility, yes, absolutely. That becomes a tax deduction on the return. So if you have caregivers coming in to take care of yourself, others, it's a deduction medically.
So what about cost in assisted living?
Yes, assisted living as well.
Okay, so what about, and I'm doing this purposely, I'm not trying to
Okay.
pick on Pam, but skilled nursing would be the same thing?
Yes.
Memory care would be the
Yes,
same thing?
memory
What
care.
about independent living?
Independent-
Healthy, just tired of the house, I'm gonna move to community X and live in independent living.
No,
Okay,
no.
because
Absolutely
it's
not.
like
No.
renting an apartment
Yeah, no, absolutely not.
with great amenities.
No. If it's not for a specific medical purpose, meaning I'm going to move to the villages because I like living there, then no.
So the differentiation is if you're independent and moving in a community where you're in the independent side, any medical things you incur while you're there, you break your ankle or you have to go to the doctor, certainly that's deductible, but the rent and the payments to that community for living in that independent apartment are not. There are some quirks in what we call the continuing care retirement communities, and that's a whole nother conversation we won't get into. That's when you're sitting in that community with like Gladys at the Mayflower, they're gonna explain all that to you. Did I miss anything on tax deductions about, as far as we age? It's all medical.
It's all
Has to be
medical.
Okay, from a financial perspective, we get into this long-term care insurance. Should people be looking at long-term care insurance?
Absolutely.
And is there a practical, we covered this in a lot of detail before, but is that deductible, the long-term care
Yes,
insurance?
it is. Long-term care is deductible on your tax return.
So we've tried to whet your appetite for a lot of things here. And the last one I want to talk about is, we talked about the people are accumulating quite a bit of equity in their home over the years, and it could be very substantial, hundreds of thousands of dollars. Is that equity a good way to fund retirement in a retirement community?
Yes, I think it's a very smart way to fund your retirement.
Do you find, I mean, we kind of see people go, oh, I can't spend that.
You can. It's yours. You earned it.
Well, I think it's their money, our money,
Correct.
and for ourself, for our care, right?
Correct.
Any-
Absolutely.
Linda, I know you deal with this all the
This-
time.
oh, yeah, yes, I concur. And for many of my clients, a home, especially these days, is the biggest asset they own. And you're not taking a house, selling it, then going on a cruise and saying, okay, what now? You're selling a home and moving into another home with it. It makes perfect sense. For many people. That's my legal disclaimer. Maybe not 100%, but many people.
Well,
Getting into the tax ramifications of long-term care, I haven't fully investigated this, but I've heard there's some insurance policies that include long-term care. So with that, what would be the tax,
So-
implications?
So the general question is tax implications of long-term care. At our ages, we've got, we probably, I think from a practicality standpoint, around late sixties, getting into long-term care is not practical anymore. But the tax benefits, there's the old policies, the newer policies have a life insurance component to them.
Right.
Is that something we can really talk about here, or is that something you really need to sit in front of?
You do need to sit and look in front, you know, how your policy is set up, and whether or not it becomes taxable or non-taxable.
And the people that really can help you with that is our folks from Evershore, Dana and Sean. And so I'd ask you to talk to them afterwards. They do a lot of work in that area, so they're very familiar with it. And they know if there's a legal tax issue, they know who to get you to, Pam, but they answer a lot of your questions. So I encourage you to stay after. Also, all of our partners will be here afterwards to talk. Questions? What questions do we have? You did such a great job with questions. Nobody else has any. So was this helpful
Oh,
today?
there's one more question.
Okay, Norm.
Another issue, I was told that if you have a safety deposit bank in your bank, and that is, once you pass away, it goes to the state, or you don't have access to that?
Okay, so safe deposit box, excellent question, because people forget about those and they don't tell anybody about them. So I'm gonna change your question. What do they need to do to make sure that the personal representative has access, other than making sure they know about it, access to that safe deposit box at death?
Okay, well, first of all, Paul answered his own question to a large extent. For safe deposit boxes, and pretty much any other asset you have, you need to keep a list. And although I am very electronic with my paperwork, this list should probably not be electronic. It should be with your hurricane bag or your grab-and-go binder that Lynn talks about, so that whoever is working with you or for you, whether during lifetime or death, knows what you have. So, safe deposit box absolutely needs to be on the list, and the bank and the branch for that. For other types of accounts, just list the bank, because the branch doesn't matter so much. How you get access to it? Well, the easiest way, if you have a trusted family member, is to make them, put them on the box now. I don't always recommend that. I have a real love-hate relationship with joint accounts. So I can talk to you or whoever wants afterwards about it. The other thing is,
Well, in regard to that though, there's only one key. So though their name might be on the box, the key's with your grab and go
Go
binder.
box,
With your
absolutely.
stuff.
You get another key.
Well, you don't have to give it to them.
No, but
Right,
I mean,
and-
you can choose your other.
Right, but that's a good safety mechanism too. That addresses some of my concerns about having a joint owner on your safe deposit box. If you only give them a secret code to be decoded at your death where the key is hidden, then you know they won't be going into it. during your lifetime when you don't want them to.
So we have another question?
No, I'm gonna ask for later, I decided this is just.
Okay, so Joanne, you got one up here.
I did it.
And what do we call that? Senior moment. And that is normal. Don't worry, we learned about that earlier in the year. What other questions? Well, thank you guys. Did we try to study anything? I always ask that. I have to. I trust that this was valuable. We tried to touch on a lot of different things today, not really go into anything in great depth. All of our partners are going to stick around, so please go visit with them. We failed to introduce our partners today, so they're going to all be in back, so please go back and see them. Next week, or next month, please bring somebody with you. Downsizers Club folks, we'll see you in a few weeks. Anybody else interested, see Beth or Lynn, and they'll help you with that.
Paul, may I make one quick comment about Downsizers Club?
Yes, ma'am.
I had some clients in my office yesterday who had attended and really enjoyed it, so I will give you that secondhand testimony.
And if you're interested, see Beth and Lynn. Closing quote for you. Estate planning is the everlasting gift that you can give your family, and that's by Susie Orman, who's a financial advisor. So thank you so much for coming. God bless, and you guys have a great week.